Greetings, colleagues and enthusiasts of Corporate Law Channel, a program through which I serialize some of the leading corporate news items in Kenya as carried in local daily newspapers, particularly in the Business Daily newspaper. Now, this is episode 3 of that program. In episode 2, I discuss the concept of a company share, how it can be attached, sold, and delivered in the process of execution of a court judgment, and the rights that whoever buys the share acquires. Now, in this episode 3, I will shift gear and discuss debt finance raising an international finance market through a debt instrument called Eurobond. Now, the story that will guide our discussion today is the story carried in the Business Daily newspaper, which is for January 20th, 2022. It is titled Kenya Retains Citibank and JP Morgan for 250 billion Eurobond. Now, the gist of this story is that Kenya is undertaking a fifth bond issue called a Eurobond issue. And the arrangers for that issue are two multinational investment banks, which are headquartered in the US, called JP Morgan and Citibank. Now, there are two local banks that are co-managers for that bond issue, I&M Bank and NCBA Group. Now, as at the date of this news item, it is reported that there are certain details of that bond issue that are still not finalized, particularly on the tenure, the pricing, and the timing of the bond issue by the arrangers. If you get the actual news item, you will come across two words that are used there interchangeably. Essentially, they mean the same thing: arrangers and managers, as I will discuss shortly in my commentary. So we can start by first really understanding what a bond is before we even speak about it being issued. So a bond is a variant of a debt instrument. Companies, corporations, and even sovereign governments, in the course of their affairs, they need money. They can raise money through borrowing. And borrowing takes very many forms. Okay, if it is for, say, a corporate, it can borrow from a commercial bank through a loan. But also, if it is a company that is trading in a recognized stock exchange, they are allowed to issue debt instruments, the kind of IOUs, okay, through which they can raise finance. These IOUs, generally they are called bonds, but as I will discuss shortly, there are distinct characteristics of the various debt instruments based particularly on the tenure of the instrument itself. So a bond is a variant of such a debt instrument, and the essential characteristic of a bond is a promise by whoever is issuing this particular debt instrument that it will pay the holder a specified sum of money at a particular specified date. Okay, so historically the bonds were called bearer instruments, and what that means is that whoever was a holder of that particular bond or debt instrument was deemed to be entitled to be paid by the issue of that bond. So that is the concept of the bearer instrument, that whoever held that particular bond at a particular time would be deemed to be the one who is supposed to be paid by whoever issued the bond. Now, that of itself, of course, raises a number of issues. So, for instance, you are an investor in a corporate. Before you even come to the gist of the story, you are an investor in a corporation that issues bonds to investors to raise money. and you are walking along the streets of Nairobi, you had your bond in your bag, and by chance, it is either taken away from your bag, or you misplace it, or you drop it. If someone picks that bond in the streets of Nairobi, okay, the particular person that picks it, who is can call it a thief, or just for simplicity. Of course, that particular person may not necessarily be entitled to payment under that bond, but that thief can pass a good title to if they transfer that bond to another party that did not have notice of the theft of that bond, and so is a transferee in good faith. Okay, so you can see in its physical form as a bearer instrument, bonds were susceptible to a number of risks, and that's why I think we have reached as a country, the bearer bonds are no longer so much in circulation. There's a concept called dematerialization, where there is the electronic holding of these bonds in a central securities depository. And that, of course, has helped in a very major way to address some of the security risks that were associated with bonds as bearer documents. Now, so what is a Eurobond? So, we've said a company or a sovereign government can raise finance by borrowing, by issuing an instrument called a bond. If that bond is issued locally, like through Nairobi Securities Exchange, it is called a bond. It's just a bond, which we'll see their variants in shortly. But there are instances where highly reputable, it's called investment grade companies that are known internationally are able to raise finance, not just locally, but in an international finance market, particularly in a stock exchange other than their home jurisdiction. Now, if that happens, then we say that that is now a Eurobond issue. It is a bond issue in an international finance market. At the very least, a finance market other than the finance market of the home jurisdiction of the issuer. So when we see the title Eurobond, it is just a bond issue, like Kenya would, the central bank, those who are familiar, they will know frequently the government raises finance through bond issues in the local market, and they're just bonds, government bonds. Now, now that the government has gone beyond the jurisdiction, that is the whole idea of a Eurobond. Raising of debt finance by issuing a debt instrument in an international finance market. That is the whole idea of Eurobond. Now, bonds exist in various variants, and the key distinguishing feature is always the tenure. One of the things that we are told in the news items that is not settled, and we will see shortly why it takes time for the arranger to do that. So the shortest tenure of a bond, a variant of a bond, is from 1 month. There's a variant from 1 month up to 1 year. They're called commercial papers. Okay, so this is a variant of a bond that is not that is floated for up to 1 year. Okay, meaning at the end of the year, or whichever period within 1 year, whoever has issued this bond is to pay whoever the subscribers, the bondholders, the people who purchase this bond. They are called investors of that bond. Now, there are some bonds that extend for periods longer than a year, say from 1 year, some say up to 5 years, between 5 years up to 7 years. Those are called notes. Okay, those who are familiar with the business news, you are aware that there's a company, a reputable company in Kenya, EABL, that issued what they call notes. Okay, so I want to believe that the tenure of the bonds was within that period of up to 7 years. Okay. Now there's a third variant of a bond which are of longer tenure. Okay, from 5 years. There's a bit of overlap between notes and bonds, in the sense that any bond, any debt instrument issued from 5 years and more, others go up to 25 years, they are properly so called the bonds. But generically, the term bond has been used, whether one is referring to a commercial paper or a note, or strictly speaking, a bond. Okay. Now, who are the parties? Who are the parties in a bond issue? Of course, we have the issuer, the particular party that is raising the finance. In this case, is a sovereign government that is raising the money in an international financial market through a bond issue. Okay? Now, that is not the only party that can raise money through a bond issue. County governments, like in our country, county governments can actually raise finance as an optional means to finance their affairs through a bond issue. Okay? If you read the provisions of Article 212 of our Constitution, county governments have the powers to borrow, provided two conditions are met. Okay? Either the national government guarantees the loan, and there is an approval by the county assembly. So county governments can also issue bonds. Okay? Then there are investment grade companies that are trading in a recognized stock exchange. Like we've just talked the issue of EABL, which I think was in the news item a few weeks, or I think a month or so ago. Okay, and it is reported they floated a note, which is a variant of a bond, to raise up to 11 billion shillings through a bond issue. Okay, now there are other parties, that can also issue bonds, special purpose vehicles. At times, and this is a problem that may be very much common in our country. At times you may find that a group of companies engages in a number of activities. Say it does manufacturing, it does real estate, it does farming, it does other activities, but not all these activities do well. Okay? So ideally, if a bond is issued by, say, a whole company, like in the case of EABL, I don't know the specifics, so I just want to, I'm making an assumption here. If a company is to, raise finance through a bond issue as a whole entity, there is always a preceding step of, assessing the credit trace that whoever will be investing in this bond takes. And that is important to determine the price at which this bond will be issued. Okay? Now, if there are instances where the issuer of the bond may want to obtain financing cheaply, perhaps in its company-wide activities, it has, one line of activity that is doing very well. For instance, real estate business. Within the group, the real estate business is doing well. They are guaranteed of a particular amount in rent every month. Okay, so it can decide to compartmentalize, to strip out that part of the business that is doing well, and use it as kind of a collateral for financing. That is a concept called securitization financing. Now, where this special purpose vehicle comes in, and I hope we'll get a chance to discuss this concept in depth, because it involves a lot of issues. There is a distinct company, new company, that will be set up, to which this portfolio of assets that collateralize or secure the bond issue are transferred. Okay? Then the pricing of the bond that is to be issued is done independently by assessing the credit risk of this particular line of business, not the company-wide risk. So in the example I've given, for instance, if only real estate business, line of business, was doing well, okay, and manufacturing is not doing well, farming is not doing well. If the company were to raise finance as a group, as the entity as a whole, its credit quality will be lower because the risk will be the risk of the company, of the entire company, okay? So, but if they compartmentalize a particular business, which is perhaps the best performing line of business, it enables that company, and I'm making the assumption that this is a company that is trading at the Nairobi Securities Exchange, okay? So, the company will be able to then issue shares, not shares, it will be able to issue the bonds by relying on this, portfolio of assets that are of higher grade as compared to company-wide asset quality. So that is, so the company that will be formed to facilitate that kind of financing is called a special purpose vehicle. We'll get a chance in future because there are so many issues that are involved in securitization financing. And of course, there are international organizations that can also issue bonds, like Africa Development Bank, World Bank. So in this context, yes, we are seeing only Kenya, a sovereign government issuing the bonds. But the point is, we need to know that it's not only a sovereign government that can issue bonds or raise finance through a bond issue. So other than the issuer, there is a lead manager. Some people call it the arranger, and those are terms that appear in the news items. Now, there are specialized investment banks that actually play a key role in managing a bond issue. Those are the so-called the lead managers. Their primary role is what in finance called book running, maintaining the interests of the investors in the bond. And they do that through a number of mechanics. So ideally, people, whenever an issuer, like we would expect the issue by the Kenyan government, there was some kind of a bidding, competitive bidding by large investment banks who would then manage this particular issue, okay? Up to the point where it is sold and the subscription money is delivered to the issuer, and the finance that is sought is then obtained by the Kenyan government, okay? So Citibank and JP Morgan are listed as the lead managers because of the amount involved. There are instances when you will only have one lead manager, but because of this, 250 billion is a lot of money, okay? There are co-managers that have been incorporated into the bond issue process, and we are told there I&M Bank and NCBA Group are co-managers of the issue, okay? Now, other than just maintaining the investor confidence, as we'll see shortly, the reason why most issuers go to some of these highly reputable investment banks is because of their networks. They are able to bring in, to instill confidence in potential investors that would then subscribe to the bond issue, to enable the issuer then obtain the money that it seeks. It's called putting together a syndicate of investors, people who will invest in almost substantial part of these 250 billion that the issuer is seeking to raise. And some of those syndicate investors are large financial institutions, and including banks, insurance companies, among others. Now, there are legal advisors. There's a lot of legal work that is involved in a bond issue. The lead manager ordinarily would have his lawyer. The issuer would have his lawyer. Then there's a party called a security trustee, where once the bond is issued, remember there will be, there will be the enforcement part. People are investing their money in this issue as investors. They expect to be paid. And it's not always that they will be paid without friction. So a trustee, a security trustee, is always appointed as one of the necessary parties during a bond issue, is appointed by the issuer, but is not an agent of the issuer. Is actually an agent of the bondholders, the investors. And the primary duty of a security trustee is to monitor, the enforcement of the bond issue. Where there is security, if the bond is secured, it's not clear if this one is secured, but if the bond is secured, the legal title in that security always vests in the trustee, and the investors are beneficial owners. They have a right to benefit from the enforcement proceedings. Now, within the bond itself, remember we said that a bond is an IOU, is a promise by the person issuing it that on a particular day I'll pay you a particular amount of money at a particular time. Okay? Now, that is called a covenant to pay. It is, for those who are familiar with a bearer bond, is actually contained on the face of the bond itself. Now, what creates a trustee is called a trust deed, which is a very detailed document. Okay? And the key issue that I wanted to highlight in respect to a trust deed is that a trust deed contains a similar covenant. And that is key, particularly for lawyers. Okay? A trust deed contains a covenant to pay the trustee. Remember we said that it is the trustee that enforces the debt, enforces this payment of this bond by the issuer on behalf of the bondholders. A trustee can only do that if there is an obligation to pay it. If he owns security in his name as the legal owner, you can only enforce security in law if there is a debt owed to you. And that's why, among other provisions, the key material issue that I would wish to highlight is that there is what is called a parallel covenant to pay in a bond issue on the face of the bond itself and on the face of the security, the trust deed. And the beneficiary of the covenant to pay in the trust deed is actually the trustee, is a commitment by the issuer to pay the trustee. It is through that covenant that then the trustee acquires the right to enforce the security if the bond issue is secured, that towards enforcement of the bond issue. Now, another party that is always necessary in a bond issue, what I call paying agents. There's a principal paying agent appointed by the issuer, okay? And their role is to pay the bondholders. In practice, like now for the Eurobond, where the bond is issued in an international finance market, in that particular finance market where the bond is floated, assuming for instance at the London Stock Exchange, one of the things that would ordinarily happen is that other than the principal paying agent that Kenya appoints, which can be even a Kenyan bank, in the UK, assuming that is floated at the London Stock Exchange, there will be other paying agents, okay, that will be appointed there. And the primary role of these paying agents in those jurisdictions where the bond is floated is to actually make the payment even where the principal paying agent has not remitted the money to this paying agent in the foreign jurisdiction. That is important because there is what is called a liquidity mismatch. Perhaps maybe the Kenyan government expects to pay for this bond when it is due by you through taxes that it collects from its citizens. And there is a shortfall or a delay in the collection of those taxes. These paying agents in the jurisdiction where the bond is floated are expected to pay those bonds when the interest, particularly the interest, when they are due, okay? And then they recover that amount from the principal paying agent, which may be a Kenyan bank, okay? So if an issuer fails to pay for a bond when it is due, okay, there are certain drastic legal consequences that arises. So to navigate on, to prevent those consequences, there's that liquidity mismatch, which is resolved by appointing 2 layers of the paying agents. And maybe just to highlight, before we go to the last part of this recording, which is on the process itself, we said lawyers, there are lawyers that are engaged in a bond issue. Ideally, one of the things that a lead manager does is to determine the governing law of a bond issue. Okay? And ordinarily it would be the law where the bond is actually floated. For instance, if this is floated at in the UK, the UK law would, the English law, for instance, would govern the bond issue. But that does not mean that only English lawyers can be appointed as legal advisors. Why? Because the issuer is not wholly resident in the UK. Okay, so there is need for compliance with the local laws, and that's why ordinarily you would expect that, because now this is a bond issue by a sovereign government, okay, amongst the legal advisors that will be appointed in this issue will comprise perhaps some English law firms as well as Kenyan law firm, particularly to advise on the implication on this bond issue under Kenyan law. Okay, so lastly, we can highlight, as I conclude, on the process of a bond issue. So the process actually starts by, appointing a lead manager, which I think is a stage where the Kenyan government is at right now. Okay, now the lead manager, once appointed, does what is called a roadshow. And the roadshow involves, introducing this issue, this Kenyan government. They introduce this Kenyan government to lead financial centers in the world. So they're expected to travel to a number of financial hubs in some of the major cities in the world to introduce this particular issue, which is our Kenyan government, to potential investors, so that those who are not aware perhaps of the potential that we have locally can then be informed of this particular issue. Now, once the roadshow stops, then the lead manager starts preparing what is called an offering circular. Now, the offering circular can take the form of either what is called a prospectus, if eventually this bond is expected to be listed to the public for subscription. There are two layers of subscription to the shares at the point before it is traded to the to the entire public, and after it then trades in what is called a secondary market. Now, the document that originates that public listing is called a prospectus, and it is one of the primary roles of the lead manager. Alternatively, there is a document that is called a listing particulars, okay? And we are speaking in the context, I'm assuming that this particular bond will be listed at the London Stock Exchange, okay? If the issuer were, say, a sovereign government, particularly within the former EU, or an international organization within that region, okay? Instead of a prospectus, there is a document called a listing particulars, which would have been prepared. And the material difference between those two kinds of offering circulars is on the content, okay? The extent of disclosure. In a prospectus, there are three key disclosures that are always given. One is the registration statement, which informs the prospective subscribers to these shares about the issuer. Who is this issuer? Okay? So in this case, it will be about the Kenyan government, the economic outlook of our country. Okay? Then there is the statement about the issue itself. Okay? The note issues. Okay? So there will be a description of the bond issue, so that whoever intends to subscribe in the shares get to understand, okay, what is this issue about. And lastly, there is a third part on the risks, okay, the risks that subscription on this particular issue will present. Now, where the prospectus differs with the listing particulars is that part on disclosure of the risks that are involved in subscribing to these shares is omitted. Okay, and that privilege is only given, I believe, to sovereign governments that are well known within that region. So I would expect that for our case, okay, because it's not one of the prescribed entities that are eligible to float, to register a listing particular, they will present a prospectus. That is again assuming that this particular bond issue will eventually be floated to the public for subscription. Not all bonds are floated. There's what is called a private placement. If there are a particular group of investors who the lead manager knows will avail the financing to the issuer. But let's assume that this particular issue will be floated. So there will be a prospectus. Okay, there is an interim prospectus, preliminary prospectus. Some people call it a red herring, which they prepare firstly to test the demand, and it is always targeted to some potential large institutional investors, so that particularly they know the demand, because that demand is necessary for the lead manager to understand the price at which this bond issue will actually be floated. So once that red herring, that preliminary kind of a prospectus is prepared, it is required to be registered. And registration happens at two levels. There is a securities regulator. If it were to be a local bond issue, it would be sent to Capital Markets Authority and simultaneously to the exchange where you expect to list. Okay, so it would be Nairobi Securities Exchange. Now, assuming that this one will be floated at London Stock Exchange, it is sent to Financial Conduct Authority, which is a securities regulator in that country, and LSE, the London Stock Exchange, which has its own rules for listing. Okay. Now, once it is approved, the purpose of sending it is for approval, and it is a criminal offense to issue a prospectus to the public without approval by securities regulator. So, assuming that eventually it gets approved, there is a third step of selling this bond. Okay. Now, the selling that I'm talking about here is not for the general public. Okay. It is to potential investors in the bond. Remember, at this time, the Kenyan government has not gotten the 250 billion. Okay. And at the stage when the preliminary prospectus was being floated, the assumption is that the lead manager together with the Kenyan government have already settled on the tenure, the pricing, which they are talking about here. They will now know the price. And so the final prospectus contain all that information. So based on that information, it is then sent out to potential investors so that they can express interest. Okay, what portion of these 250 billion will each potential investor subscribe to? Okay. Then assuming that they subscribe the full amount, there is what is called a clearing system through which those who subscribe to the bond have their accounts within the clearing system credited with the equivalent number of bonds that they subscribe to, and of course they're expected to pay the cash equivalent of their cash of their subscription. The entire cash that is collected is firstly deposited into the lead manager's account within the clearing system. Then the lead manager eventually gives instruction to for the money to be sent to the issuer's account, which in this case is the Kenyan government. So there will be a designated account into which the amount will be sent. Okay, so that actually is a summary. There are so many legal issues that arise that we may not have the chance and the time to discuss here, but that summarizes the process of how the bond issue. Eventually, the Kenyan government gets the money. Now, remember, there are people who have bought these bonds, the investors. It is true that they expect that the Kenyan government will pay for the bond, periodic interest, and when the tenure, which is eventually settled, ends, both the principal and the interest will be paid. Okay? But it is not always that whoever buys the bond will retain that bond in its balance sheet, in its books, for the entire tenure. If it's, for instance, a 25-year bond, they may want to trade this bond. Okay? And that's why there is now the second step of trading this bond to now the general public in the secondary market, or whichever securities exchange it is listed, assuming it is London Stock Exchange. Okay? So the general public then will have a chance to buy the bonds. Okay? If whoever subscribed for it initially is willing to trade in that bond. Okay? It's a very liquid, it's called a liquid debt instrument, which you can easily transfer through now the clearing system. Remember, it's no longer a bearer instrument. Within the clearing system within that country, it can be traded. Okay? So the issues that I will discuss in episode 4, I will still stick, because of the significance of this topic, I will stick with it in episode 4. Assuming that in the prospectus, there were certain misstatements that then occasion some potential risks to the subscribers to the bond. Where does liability lie? Okay? And how these investors in the bond then protected? Okay? So we look at the procedure for enforcement of remedies by investors, investors in a bond issue. So that will come in our next episode. Thank you very much for today. I hope that this summary gives some insight into the process of a bond issue, particularly a Eurobond, not a local bond, it's a Eurobond. And we look forward to again discussing the remedies that are available to the subscribers of the bond, and against whom those remedies lie. I hope to record episode 4 of the program sometime early next week. Once again, my name is Mathews Okoth, and thank you for listening to me. Bye-bye.